Well, divorces that land in the courts typically pit one person against another, but sometimes the judge will order mediation. To find out why, we turn to Live at 5's attorney, Sonia Kaufman. So, does it really make sense when you're paying for an attorney to then go to mediation? Does it end up costing more?
It does cost more in attorney time, but we have a great center here, the Dispute Resolution Center, where cases can be mediated very inexpensively from the mediator standpoint. And that's because they have great volunteer mediators who donate their time. And statistics show that about 90% of the cases that go to mediation settle. So it's usually a good idea to spend the time to see if it can be worked out.
So do you need to hire a lawyer if you, in fact, go to mediation?
Not to mediate per se. The Dispute Resolution Center mediates cases all the time without lawyers, but to handle the divorce aspect, you probably do need a lawyer for that.
All right, on to some of our other questions. I was divorced 5 years ago and recently found out that my husband had a retirement account that I didn't know about. Is it too late to ask for my share of that?
No, if part of that retirement account was community property during the marriage.
Even 5 years after the divorce?
If the spouse has not repudiated or said, no way, no how, I'm going to give you any of that, because that starts the statute of limitations running. And from that point forward, a spouse has 2 years to bring a suit to petition or to divide property that was not divided in the divorce. So if the spouse just learned of it, then it's not too late.
Okay. I'm thinking of getting remarried. Will my child support increase because of my wife's income?
No. The court will not consider a spouse's income in figuring child support.
So as far as child support itself goes, can that ever be altered once it is established in the court what the amount is?
Yes, through a modification proceeding, either through a private attorney or through the Attorney General's office. If there's a material change in circumstances, that can be modified.
Okay. My divorce was final 2 months ago and I was awarded primary custody. My husband is meeting with his attorney to take me back to court to get custody because he says that my daughter wants to live with him. Can he do that?
Wow, that's the last thing somebody wants to hear 2 months later, isn't it? The answer is probably not, because to change the person who has primary residence within a year, someone would have to show that, file an affidavit with the petition showing that the child is in danger with that other parent. So provided there's not been any big change in circumstances, that would be very difficult to do. And the reason is the law gives you that grace period after you've been to court without having to go back so quickly.
Now, what about if the kids are a certain age? At that point, can the kids decide, even if the courts have already decided this is who primary custody belongs to?
The child can express a preference in chambers to the judge of where they would like to live, but that's not binding on the court. The court determines best interest. But to file a modification within a year, it's a very specific basis on which that can be done, and the preference of the child is not one of those within that year.
And you're probably also looking at additional cost going back to court.
Absolutely. The last thing somebody wants to hear.
All right, Sonia, thanks so much. We appreciate it. We've got lots of other questions, and we'll get to those next month. And if you have a question about family law, all you have to do is fax us those questions at 892-7305 or email us at laf@kftm.com.